Yeah, thank you very much for the kind introduction. It's of course a great pleasure to be part of this academic birthday party for the 10th anniversary of the Hungarian Civil Code, which I very much admire, especially in the area of succession law, where it is really very innovative. Yeah, unlike the young boy, the young Hungarian Codex, which is described by Lajos Vékas as a late codification, a young codification, a verspätete codification. The code which I have to present to you in the next 20 minutes or so, this code is rather grown up. It's an old man or an old lady already. And this code has gone through many phases, but, and this is really rather astonishing, it survived history. The code was born, it's a child of the 19th century, it was born in the Second German Empire, which was a kind of constitutional monarchy, probably a little bit absolute monarchy, but with some elements of constitutionalism. It, as a young man, it lived in the first German Republic, the Weimar Republic, a small phase of democracy in German history. It even survived and also contributed, one has to say, to the atrocities of the Nazi time. Unchanged, the same code which applied a couple of years before in a democracy. It flourished, one has to say, especially in literature, but also in jurisprudence. It flourished in the Western German democracy. And it even lived a couple of years in the East, which was, I just noticed on one of the slides of the previous speakers, a sort of socialism. It was socialism, I think. Yeah? It survived socialism, at least until 1976, when it was abolished by the Zivilgesetzbuch der Deutschen Demokratischen Republik. And it's still in force today, and mainly unchanged. Some parts of the book of the BGB are still in force as they were when the book was first published in 1896. Yeah, but just allow me, before addressing some of the reforms of the BGB, the big German book, as the Dutch always call the BGB, before addressing some of the reforms and also the challenges to the BGB and the codification idea in the BGB, to recall some of the facts surrounding the BGB, which most of you will probably know anyhow, but I just want to recall them. Yeah, as you all know, the BGB is the comprehensive codification of German private law. It covers all areas of private law, except commercial law, which is part of the Handelsgesetzbuch, the HGB, which was even enforced before the BGB was adopted. Yeah, as you can see, the book was adopted, the BGB was adopted in 1896. It entered into force in 1900 after a long legislative process. I just, on the way to Budapest, I read in Zweigart and Kötz that apparently the date, 1st January 1900, was deliberately taken by the emperor himself, William II himself, because he wanted to open the new century with a huge codification. I think that's not true. I think Zweigart and Kötz are not right on this, because I checked the act was signed by the emperor. It was signed. We know when. It was the 18th August 1896. We also know where. It was in the new palace in Potsdam, but we don't know the time, and therefore I tried to find out what happened on that day in the new palace. And it's quite new. It's a digitalization of the imperial agendas. They are now on the internet, published by the Berlin-Brandenburg Academy of Science, and I checked the agenda, the imperial agenda of the state. It was a cold day, 70 degrees in Berlin, a rainy day in Berlin, 17 degrees in August, and there is no mentioning of the Bürgerliche Gesetzbuch. The emperor started the day riding the horses, looking after the horses. Then there was a parade. He exchanged letters with His Majesty, the King of Saxony. And of course, it was the birthday, it's a coincidence, it was the birthday of the Austrian Empire at that day. And there was a birthday supper in the palace. So it's no mentioning of the BGB. So the BGB, I think, was of no importance for the emperor. And the emperor, who was a bit lazy, just signed it in between looking after the horses, probably. Yeah, you all know that the BGB follows the Pendact systems, so this was already mentioned before. So we have a general part, we have a law of obligations, which is quite comprehensive. We have a property law part, third book. We have the fourth book, the family law book, and the fifth book, the famous fifth book, the provisions on succession law, which haven't been changed almost at all until today. Yeah, only parts which are outside the classical areas of private law, which are outside the book, are private international law, for example. Private international law is not part of the BGB. It's part of a separate act. It's part of the introductory act to the Bürgerliche Gesetzbuch, the so-called EG BGB. Yeah, it was already mentioned, I think, by Christiana, that the BGB is a rather theoretical piece of legislation. It employs a rather abstract regulative technique, the so-called Klammertechnik. I checked who invented this word, Klammertechnik. Was invented by Gustav Böhmer, which means that certain questions which apply in all areas of the law, they are regulated in the general parts. They are regulated in the beginning of the book for all parts of the book. So it's really rather it contains rather general provisions and is rather theoretical insofar. We have general rules in the first part on contracts, juridical acts especially, declarations of intentions, and those provisions, they apply for all areas of law. So a contract, from a German perspective, is not only a sales contract or contracts in the common law sense. A contract is also a marital agreement. Yeah? It can also be, an agreement on parental responsibility. It can be a waiver of succession rights. It's also a contract. And the same provisions on the formation of contracts apply throughout the whole book. The same applies to juridical acts. The recognition of fatherhood is a juridical act, a Rechtsgeschäft, but also a contract is a juridical act, a special form of juridical act. So this is all very abstract and very theoretical. So also the language is not at all addressed to the people. It's addressed to professional lawyers, not to all lawyers, but only to private lawyers. So criminal lawyers don't understand the BGB. It's really a book for specialists, and for private lawyers, it's rather elegant. So once you understand the language of the BGB, it's a pleasure to apply it and to read it, at least the old parts of it. Some of the newer parts are not that elegant anymore, but the older parts are very, very efficient and with small sentences try to regulate lots of legal preconditions and consequences. The BGB is always regarded as a liberal code, so a child of the 19th century liberalism. Freedom of contract in the first version of the text was almost unlimited, not only in the law of obligations, but also in family and especially in succession law. I think this is also still, German law in the area of succession law is one of the legal systems which grants as much contractual freedom as possible, much more than the Romanist, the French Civil Code, or the Italian Codice Civile, for example, when it comes to succession agreements, so that the testator, by a succession agreement or by a mutual will, can bind him or herself, can limit its own testamentary freedom, that you can agree on future successions. All those are things which are not common in other legal systems. So here we have really a true contractual freedom throughout the areas which are governed by the civil code. Yeah, in the beginning there was little, there was no consumer protection. There was some early reforms regarding tenancy. Zweigert-Kötz call the BGB as a piece of legislation which is inspired by the spirit of cold individualism. So there is no protection of the weaker party. There were some first reforms in the area, as I mentioned, in the area of tenancy law, which introduced, to quote a famous saying of Otto von Gierke, who introduced some drops of socialist oil in the individualistic and liberal codification. Yeah, it's also known to probably everyone in the audience that the BGB was also received in other legal systems, especially in the Far East, in Japan and Korea, but also, of course, some elements in other states as well, in Greece and, of course, also in the Baltic states. Yeah, during the last 123 years, the BGB, of course, has undergone some reforms. However, it is noticeable that we have almost two parts of the BGB. One part which is really static, and another part which is rather dynamic. Let me start with the dynamic parts. We have especially two areas of the BGB which were object of constant reform. One is the law of obligations, which was in particular comprehensively reformed in 2002. This was really a huge reform. It was really a different law was introduced. I did my first state exam in 2002, and I had the impression to study a new legal system. It was something totally different from the time before. But of course, there were other smaller constant reforms in the area of law of obligations as well, sectoral reforms, for example, regarding the general partnership just recently, general partnerships company law. The general company was also reformed recently, but also certain contracts were introduced. For example, a special form of a service contract regarding medical treatment. The case law of our Supreme Court was codified here. And of course, all of the EU instruments in the area of consumer protection, which mainly, of course, concern law of obligations, were also integrated in the code. The most dynamic part of the BGB is, however, family law. Here, I think a family lawyer from 1900 wouldn't understand a word of the actual code. I think there's no provision apart from engagement. I think the provisions on the engagement, they are still the same. They're not used in practice anymore, but they are more or less the same. The rest of family law is totally different. We had huge reforms in 1957, abolishing discrimination of women, 1969, abolishing discrimination of children born out of wedlock, in 1976, the huge family law reform, especially regarding divorce, so abolishing false divorce, introducing divorce based on objective grounds and also on consent. 1997, splitting marriage from filiation and from parental responsibility. 2001, introducing same-sex partnerships. 2008, a huge reform of the law on matrimony property, 2017 introducing same-sex marriages, and 2021 is apparent, I think probably the reform where most of the provisions, or the reform where the biggest numbers of provisions of the BGB were changed. It concerned only guardianship, but guardianship is regulated rather comprehensively, and everything, most of this part of the law was reformed just 2 years ago. Yeah, we have many reform projects pending, especially on the law of names. German private law has an obsession with names and the regulation of names. I think we have the most comprehensive set of rules dealing with names, and I can promise you that our legislator is about to to double the amount of provisions on the law of names. So it's getting even more complicated. There's a huge parenthood reform pending in Germany, and also reform on gender recognition. We are just about to introduce a private autonomy when it comes to your gender, so that you can change your gender by a Rechtsgeschäft, by a juridical act, and you don't need any procedure anymore. And we have a debate about the Verantwortungsgemeinschaft, which is, nobody knows exactly what it is. Our Minister of Justice has in mind a kind of marriage with more than 2 people, so 3, 4, 5, 6 people. I don't know. I haven't seen a couple or a group of persons looking for such an institution, but we are at the moment discussing whether we should introduce such an institution. Yeah, then we have the static parts of the BGB, which is property law, the general part, and succession law. In particular, succession law. Little has changed here. There's also little policy debate in the area of succession law. One reason for this is probably that parts of our succession law are constitutionally guaranteed. There is a decision of the Federal Constitutional Court, which came to the conclusion a couple of years ago that our provisions on forced heirship are guaranteed by the German Constitution, so they can't be changed by a normal legislative act. You would have to change the Constitution in order, for example, to abolish forced heirship. But in general, succession law is regarded as one of the best parts of the original text, and practice is more or less happy with succession law. So we have no changes, almost no changes at all. Yeah, but even, and this is my last point I would like to address, but even the good old BGB reaches the limits in the meantime of the codification idea. I tried to find some reasons why maybe the codification, or maybe why the BGB loses more and more the character of a comprehensive codification. One reason is clearly that we have lots of private law in the meantime outside the Bürgerliche Gesetzbuch. This concerns especially tort law, strict liability. Most provisions on strict liability are in special pieces of legislation. Also some family law instruments, they are not part of the BGB. For example, the division of pension rights, which is very important in practice, in German family law practice. It's not part of the BGB, but it's part of a separate act. Also the whole area of gender recognition is also outside the BGB. I think it should be in the BGB because the gender of person is like the name, like the personality is part of the person characteristics and should be part of the general part. But this, of course, leads to the fact that the BGB is not a comprehensive codification anymore. Also, we have rather dynamic areas of law, private law outside the BGB, intellectual property especially, where we have new approaches when it comes to private law. For example, remedy approaches, and they are not received at all by the general private lawyers. And this is also a danger, of course, for a codification, which in the end is only reproduces old theories and not looks to other areas of law. One danger comes from family law, as the previous speaker mentioned. Family law doesn't fit that much into the big code, and this is even true for German family law. We have an increasing isolation of family law. There is, I mean, no use that family law is part of the BGB. It's a separate book in the BGB, but no or little connections with the rest of the BGB. There are even provisions, for example, in family law when it comes to juridical acts like blocking statutes, which provide that the general part does not apply, that only family law applies, not the general part applies. And this is totally different, for example, from succession law. In succession law, we have lots of interconnections between the general part and succession law when it comes to the whole Rechtsgeschäftslehre, mistake, duress. We all take this from the general part. Yeah. Furthermore, there is a little cross-sectional coordination between the different areas of the BGB, which is also a problem. One example, I put it on the slides, is the law on foundations and succession law. We have a new law on foundations, and there is no coordination with succession law. We allow tying up property in a foundation, but we do not allow to tie up property, for example, by testamentary execution. So there's also a kind of the codification idea is losing its force here. Yeah, and of course, EU legislation destroys, one can say, at least from a formalistic perspective, the codification. Although I think, citing the unfortunately late Jürgen Basedow, that it's, of course, it has also plays a role when it comes to EU legislation in order to integrate EU legislation into the national system of private law, and this is also a kind of rest or remaining function of the civil code. Yeah, I think this was everything I wanted to share with you. My time is up, and therefore I think I stop here, and thank you very much for your attention.